We are studying about the development or origin of international law. And in this particular portion, we have tried to include what development, how the international law is developed, and we have little got little bit idea regarding that how Romans have contributed, how the natural school has contributed, how positivity, positivist school has contributed in the development of international law. So this is basically the idea we got, and we also got an idea that international law is developed with a long process. It is not like that it's just started with some sources, and like there is a concept when we will all study the sources of international law. That is a concept related that the custom we know, and the custom can be created in few years also. For example, if you take the example of the space law, it was created in a quick manner. So in like 10 and 20 years, the space law was evolved. So the evolution process at in past was different, and the development of law at present is different. That is, the law is developing more fast in a way, because at that time, whatever law was developing at that time, it was after when the Grotis has written the book, the De Jure Belli, and it was that book become university textbook. And when the people started to read that particular book, they got an idea, because other whatever knowledge of international law was there before that, that knowledge was of only oral in nature. So the development, when you write something, what happened? You when you write, you and communicate these things to other people, it helps in developing that particular concept. It is not about law, it can be applied in any manner, whether it is social science, whether it is science, or anywhere. So this is basically what we right now at present we have. As for the title of this particular class is Codification of International Law. We will go into that part also, but we will start with the definition which we have studied in the first class, because at the time that was an introduction class, and I have given the details. So I have given the details uh, get an idea of what different definitions are there. For example, if you study any subject, we go into the definition of that. And in international law, there are lots of definitions are there. Lots of scholars were working, and there the history or the development is divided in three phases. So you will get different definitions. Or that definition can be a critique of international law, and then that definition can be only a simple in nature. So first of all, what the first definition when you study international law is always you will find the book also, that is the definition of Oppenheim. Oppenheim, very famous scholar, and he has given very famous definition, and that definition was we can say has given a place to develop other definitions also. So it started, and we can say as a process where every individual or every scholar who is studying international law is giving definition of international law. So according to Oppenheim, international law is law of nations, or it is named for the body of customary law and conventional rules which are considered to be binding by civilized states in their intercourse with each other. So this was the first definition that was given by Oppenheim. And as you know, whenever you try something first, you will face some problem in that. So in a similar way, the Oppenheim definition have lots of demerits also. He tried to convince people that what is law, international law? International law is law of nations. That means it is law of nation, as you know, and it is named for the body of customary law and conventional rules. That means he tried to uh, point out that it is basically collection of customary laws, or it is conventional rules also. That means conventional rules which we make between two states, and it is applicable, it is which are considered to be binding by civilized state in their intercourse with each other. And we try to point out that, if for example, if you take that, who will follow law? The person who is civilized. Always that person will the definition of civilized can be different. So in a way he used the word civilized. That means we can interpret that he has used the word for Christian countries, but we can interpret that word in our manner, that every state which is following every rules and regulation is a civilized state. So he tried to put out that thing in a different way. But if you want to understand that concept, that civilized means you want to convey that only Christian states are civilized. But if you, in today's world, if you look into this particular point, every state which is following international norms and regulation is a civilized state. So he tried to point out that what is international law? International is nothing. It is basically law of nations, which is combination of customary rules because customary rules is prevalent at the time, and conventional rules which we generally make. And when this rule will be used, when there will be transaction between two states. So this was the basic definition of international law. Anybody can understand this concept, that what is international law? International law is basically a concept where there is a combination of customary rule and there is combination of conventional rules. You combine those things and you use with that particular norms in a way. For example, right now, if I am taking class, for example, in the first class, I may have tried or I can make some laws regarding the what decorum should be in class also. For example, I can say that you should it should come 5 minutes earlier. Is it not possible because you have earlier other classes also? I can say that you have to be log in for 1 hour. So these type of rules and convention rules I can also create for class also. So in a way that at that time international law was creation at that time, because no international organization was working. So we have customary rules and we have conventional rules only. So that was the first definition of that international law that was given by OpenAI. And the another definition which you have discussed in that class also, that was of J.G. Stark. He said international law may be defined as that body of law which is composed for its greater part of the principles and rules of conduct which states feel themselves bound to observe, and therefore they do commonly observe in their relation with each other. That means what he want to convey? He want to convey that international law, according to J.G. Stark, he said that states are following law because they are feeling that they are obliged to follow that. That means they are feeling that they have to follow this law because they are feeling that they are obliged to do that because other states are also doing, or the consent is already given. They have given the consent for that. So this is the basic definition which was given by Stark. Stark has said that international law is nothing. It is basically common principles are there. He said that is, and that particular rules or conduct which states feel that we should have to follow because they feel themselves they are bound to observe because they have already they are observing this in a we can say in the time period. They are basically following that particular thing. For example, if there is some custom and between two states that they are trading in, for example, in barter system. For example, rice and wheat is there. For example, if some state has rice, lots of they grow rice, produce rice, another state is producing wheat. So that there was a custom that they will they weigh that particular product and they exchange that product. That is barter system, as you all know. That was before money. That system was basically followed. So in on that particular custom, what they do now, they have by order of their ruler, they have started they have given a written rules regarding that what rice should become, what quantity of rice can be exchanged, what quantity of wheat can be exchanged. So that can also become a norm of international law. So between that two states only. So that can be a bilateral agreement also. So the Stark is trying to convince or trying to convey that what is international law? International law is what a state follow, and the state why the state follow that international law or the rules, because the state thinks that they are obliged to do so. So the consent is there, the consent is automatic consent, we can say, is there, that they are feeling that they are obliged to do so. So this is one of the another definition that was given by J.J. Starr. Now in this two definition, one thing is missing, and that thing is that they have only taken the consideration, or they have taken only states as the subject of international law. That is not the case in reality. States is not only subject of international law, even international organizations are subject to international law, and sometimes some international treaties also give individuals consider individuals as subject of international law. We will look into that when we in the last topic, that is subject of international law. We will look into that point also. So this is the definition which say that they only involve states, but in reality, in international law, even nowadays, international organizations are more involved in international law than states. So this was the definition, because that definition was earlier definition, so that there there should be there may be some lacuna in that particular definition, because it can happen, because in the first or second definition there can be that situation where we can say that 1 minute. So there can be changes in definition, or there are many critique of that definition. So that process would be there, because evolution of any definition or evolution of any law needs some critique. And in the first time, nobody can create the we can say create perfect definition. So we have to wait for that. And so this was the second definition that JJ is JG Stark has basically tried to convey. Now the third definition, which we all have discussed in that day also, that was of Schwarzenberger. That person would say that international law as the body of legal rules which apply between sovereign states and such other entities as have been granted international law personality. Now he, after understanding the definitions of Oppenheim and J.J. Starr, Schwarzenberger, he tried to improve his definition, and he tried to involve other subjects of international law into his definition. And what he said that international law, what is it? Is body of legal rules which apply between sovereign state. He word the word sovereign, and in place of what civilized, because there was the civilized states is already criticized by many people, because the use of that word words were not perfect by Oppenheim. So now what the Schwarzenberger has started, he will use the word sovereign state. That means sovereign state, that means nobody can basically dominate that state, nobody can change their decision. And another thing, and such other entities, that means such other entities that particular such other entities that particular that can in future they will, if that entity is granted international legal personality. That means if for example a new international organization is created, and that international organization is following all the rules and regulation, so that particular international organization will automatically become subject of international law. So whatever entities will acquire international personality in future, even that will automatically become part of this particular the subjects of international law. So this was the second definition, which was basically this Schwarzenberger has basically pointed out that whatever is going on, he basically not make that his definition exclusive in nature, but he made the definition inclusive in nature in future. That means he has said that whatever that means, if any entities have been granted international personality in future also, that entity will automatically become part of international law. So his definition was of open in nature. Oppenheim definition was closed in nature. J.J. Stark definition was more of a consent theory type, which we will study. That means consent theory type, that we are obliged to do that because we think that we are obliged to do that. I am teaching you because it is not I am obliged, because university is paying me something. So I am obliged in different manner. So in a way we can say that whatever definition is coming on of international law, these all definition have some loopholes, but Schwarzenberger has tried to control that lacuna, and he tried to basically give a perfect definition. Why his definition is perfect? His definition is perfect, but because that definition is open in nature. You can add anything in that, but he has given some criteria for that, that you can add only those subjects which have international legal personality. If the state has the international legal personality, it can participate. If a international organization has international legal personality, it can participate. If some NGOs have international legal personality, that NGOs can participate. If a non-state actor has an international legal personality, then non-state actor can participate. So these can be in future become subjects of international law, and whatever they are doing, that is international law. For example, if they are trading, that is also part of international. If they are passing some documents, they are transferring technology, that is also that type of international law. So this is basically the scope of is international law. We can say in nutshell that these definitions has provide a proper background to understand international law. That means you can easily understand international law is nothing. That means how you make your legal relation with other state. In simple form, I can say that international law is what legal relation with which you make with XYZ countries. For example, if India is making international relation, international law with Pakistan, Nepal, Bangladesh, or Sri Lanka, or Maldives, or Afghanistan, or Bhutan. So these all are basically a type of international law. So this is the basic concept which I tried to basically convey you, that the definitions are very much common in nature. You can easily understand, and don't mug up the definition. What will happen? You just have to understand the concept. In some examination, in competitive examination, the direct question will be that they will quote that particular definition, and they will say who particular person, scholar, has said this particular definition. So you can easily identify. Try to learn some words of the definition and the concept of the definition. Other thing you don't need to mug up, because what happened, there are so many definition. I am just pointing out few definition, because we have to complete the syllabus also. So I am just taking the what are the perfect definition and what are the important definition basically. Now, with the improvement, Oppenheim definition, there is a revised definition of Oppenheim also, which was basically that was written by the student of Oppenheim, and that was international is body of rules which are legally binding on states in their intercourse with each other. That was the original definition, and they have removed the civilized state concept. They have only used the states, and these rules are primarily which govern the relation of a state, but states are not only subject of international law. That means the rules international rules are that these are governed by governing subjects of international law. One minute, please. हेलो, सॉरी कॉल आ गया था कि स्टूडेंट का ही कॉल था, उनको कुछ प्रॉब्लम था. So we are studying that the new definition or the revised definition of Oppenheim. The revised definition of Oppenheim is saying that what is international is body of rules which is legally binding on states in their intercourse with each other. They have removed the conventional, they have removed the customary, and now they are just using the legal rules. First change they have made. Second, they have changed that they have removed the word civilized also. They are using the word only states. So this was the major change which the Oppenheim revised definition was there, because there was critique on this point. The main critique was civilized state, so they have removed the civilized, and what they have added, because in that particular the previous definition, the international organization was not added, so they have tried to include that in this particular definition. So first of all, they tried that rules are primarily those which govern the relations of state, but states are not only the subjects of international law, and international organization and to some extent individual may be subject of rights conferred and duties imposed upon the international law. That means they have included states, they have included international organization, and they have also added individuals as subjects of international law. But that point also we can critique that, because that individuals are not subjects of international law. Individuals are been in a way is not directly we can say are subject of international law. We need the state authority to go forward for any requirement. For example, but in European Commission of Human Rights give individual rights of, for example, to be part of some, if they can go against their state also is in that particular is CHR, European Convention on Human Rights. So uh, that that particular Oppenheim revised definition has improved a lot, but they have used they have put individuals as also subject of international law. We have to, that is not the present situation. They have improved in a lot, but there is an one critique that uh, individuals are not in some law, we can say, that is in international criminal law, which I have given in the example also, that they are subjects of international law. But in public international law, at least, they are not subjects of international law. They, because they are not direct subject, we can say, to be more precise, we can say they are not direct subject of international law. We need indirectly we can be subject of international. So this was particularly the definition related to these three or four three definitions which we can say the basically part of this particular definition concept. There are many definition. When you will see the book, there are many definition of Kelsen is there, Austin is there. So many people have given different definition. But you have to look into that particular point. In these three or four definitions are where you can able to understand the concept of international law. Otherwise, you can find many definition with different critiques also. So I will suggest that go for at least read one time every definition, because what happen in exam, they ask a definition. So it is not like that you have to for my exam you have to mug up all the definitions. Like for example, if one question is there, write few definitions of international law. I'm just giving an example. So in that case, you don't have to write every definition. You can write as per your wish. You can write Oppenheim definition. You can write J.J. Stark definition or any definition. But for competitive exam, my suggestion is go with every definition, because in exam they ask, they just put it in quote and they will ask that XYZ who is the this quoted this particular or given this particular definition. So this is my one of the suggestion. Please buy one book. And I think from next month the college will open, so you can take this book from the library also. H.O. Agarwal or S.K. Kapoor is present. Even Malcolm Sai is also there. But few copies are there of Malcolm Sai. So this is the particular now the another thing which come into picture, that the nature of international law, that is international law is a real law, is international law is true law, is international law is a or we can say strong law, or is international law is a weak law. So this type of questions come into picture, that how we have to and different critique, and the critique are basically those people who are basically are obsessed with the domestic law. I am saying that those people who have very much interest in domestic law, they will never recognize the concept of international law, because they want everything just like in place, just like domestic law. They want judiciary, they want legislation, they want executive. So if you compare two things, that will be different, because one law is basically acting or basically trying to is is of domestic law. It is working only in state, and its area is totally different. They are working on citizens only. And the another law that is of international arena, it their subjects are states and international organization. So how you can compare two different bodies if if the two things are law only, if the name suggests that these two things are law, one is domestic law, or we can say in a municipal law, and another is international law. How can we compare? And after comparing both law, how we can say that international law is not good, international law is weak, international law is not true law? So we have to look into that particular critique also, that how he has compared two different system, two totally different system. Domestic law is evolved with so many years. There was direct control of the rulers. There was democracy. These all things are there. And the another type of law that has evolved, I'm saying the history is there, but it has evolved because they in that particular development, they have to look into different other participation of other states also. So we can't compare, even though because they are critic, they can do that. So one of the famous critic is of international law is John Austin. You all know jurisprudence. So in jurisprudence also he has given command of the sovereign backed by the sanction. So he wants that particular definition to be here also. He has applied his definition on the concept of international law also. Theoretical argument, some scholars have challenged the status of international law as law, that they are not recognizing international law as law. He argued that international law was not positive law because it lacked sovereign. First of all, it lacked sovereign because nobody is sovereign in this particular international law. According to him, a sovereign is a person who receives evidence of the member of the independent political society and who in turn does not owe such evidence. Now, what he want to convey in a simple word, that what is sovereign? Sovereignty concept was given by Jean Bodin, and Hobbes also improved that particular particular we can say the theory of sovereignty. Now in sovereignty, what happened? That people are obliged to that particular sovereign. That means we are citizens. India is a sovereign country. We are obliged to be part of India, but India has no anything. For example, in a say India is not obliged to do things in reply. For example, if India is following something, if state is following something, everybody is following state, but state is not obliged to do repeat that thing. And he is saying that thing not in a domestic law parlance, he is saying that in international law parlance. He want to point out that in international law, if you are sovereign, that means nobody can change your decisions. Nobody can compel you to take decision yes or no. Nobody can decide your yes and no. So if that is not present, then you are not sovereign. So if you are not sovereign, you are not becoming part of international law. So he want to convey that positive law because it lacked sovereignty. That means in international law, what happened? International law is saying something to states, but states are not following that thing. So he's saying that there are sanctions are missing. Austin want to convey that sanctions are missing. State international organization can't punish these states, even though they are party to that. So in a way, he want to convey that is that sanctions are missing. So in international law, if sanctions are missing, it is not a type of law. It is not a positive law. It is only positive morality. International is another definition, another quote or another theory which was given by Austin, that international law is nothing but positive morality. Why positive morality? Because sanctions are missing. He has said that thing in a way. At the time the sanctions were missing, I am not saying that at the time sanctions were not missing, but nowadays the international law is improved a lot. We have lots of sanctions. It can be commercial in nature, it can be collective self-defense. So there are different types of sanctions. So export sanction, import sanctions. So this which we actually seeing in North Korea also. So this type of examples has improved a lot. They have basically this is basically at the time in the past, the concept of international was not like that, but now we can say international evolved a lot, and due to that reason many new concept has evolved and new sanctions have evolved. So now it is not like that whether international is a real law. Now that question can't be asked anywhere. It always said international law is the real law and international law is true law. So nobody can now question this particular thing. It was in past that particular system can be thing can be compared. Now another counter argument that can be given, that no municipal legal system which converts to Austin concept. He said that uh, that the another argument of that particular concept, that sovereignty, what he want to focus, that if you are not sovereign, you are not part of international law. He said that the counter argument can be there is no municipal legal system which conforms to Austin concept. Nobody is every state is obliging, if they are ratifying some treaty, they are becoming part of international law and they won't they involved in this particular concept. So they are obliged to what international organizations are doing or are asking them to do. They are doing that thing. Most of the states are following. So first of all, there is no any municipal legal system which is not following that concept. Another thing is that international legal system is unique and it should not be compared with, which I have said earlier also, that it should not be compared with domestic legal system. Domestic legal system has a robust structure, democracy is there, votings are there, perfect election system is there. So all things are in good shape. So you can't compare something which is very much in good shape or good structure and with a history of democracy with something which is just evolved like in a way evolved in proper manner in 60 to 80 year or 100 or 150 years back. So this is totally that comparison should not be there. That comparison should not be done, because it's if you're doing that thing, you are hampering the international law, because you are comparing something with so solid in nature, so perfect in nature, with something which are still evolving. International law is still evolving. Many nations are becoming part of international organization, but they are not of following. Some become part of convention, they are not ratifying the treaty. Some become signatory of some. India has in, for example, in many conventions become part of that particular convention, and they are not signing the treaty. And there are many examples of different countries also. So you can't say that that international law is not real law, international law is not real, or we can say true law. It is there, it is true law, it is uh, we can say perfect law, but it is still evolving. So another person who scholar who basically started or point out it that this international law is what he said. He is also very famous in jurisprudence. You all know that person, that is Kelsen. Kelsen, you all know,
Yes, sir.
and the theory also.
सर
So
हल्का
what
सा
was
याद
his
है तो
theory?
हो जाएगा.
What?
The pure theory of law. Pure theory थी कोई केल्सन की सर.
Yeah, it is pure theory of law. So, and there was a concept of norm and grand norm. You all know that there was we can say pyramid was there, and in the, or we can say other word you can use prism was there, and in a way that hierarchy norm were there, and at the top there was grand norm was there. So in a way and there was critique of his theory was also there, that from where the grand norm got his power from. Please sir, he is basically unable to point out that, because norm is getting his power from grand norm, but from where the grand norm is getting power, so he was unable to convince it. The theory was called pure theory of law. So in a way he tried to, because those scholars international was evolving at that time also, and he was also from the imperative school or positive school. So he tried to tried to uh, put out thing in the same way like Austin also. He started to criticize international law, and he said that international law as primitive legal order. He said that what is the international law? International law is a primitive legal order. That means it is of past. It is not law of future. It is of past. Romans followed that particular international law. Greece people has followed that international law. Mesopotamia peoples have basically has followed that law. So it is not. It is primitive legal order. Why it is primitive legal order? The sense, because it is based on consent theory, that I am following international law, or I want to follow international law because I have consented. Pacta sed servanda. Agreement should be kept. Whatever I have said, whatever said I have said in good faith. You are saying that, sir, whatever you have said, that should be in good faith. And if you have said that thing, you have to keep that promise also. That you will take class. You have to take 4 classes per week. So this is pacta sed servanda. So that particular concept he connected this particular point, and he wanted to point out that it is primitive legal order. What according to him, an advanced legal order contains both primary rules and those what are primary rules, that those imposing duties, and secondary rules comprising rules of recognition, rules of change, rules of adjudication. That means he said that this is primitive legal order. International law is primitive legal order. The reason is that why this is primitive legal order, because advanced legal system has two type of law, that is primary and secondary. What primary does? Primary does that it impose duties. Primary does what the primary rule does in advanced legal system, it impose duty. And what the secondary done, secondary rules, what they do, they rule of recognition is there, rules of change is there, rules of adjudication is there. That thing are missing in this particular international legal system. So it is a primitive legal order as per Kelsen. Now the counter argument of that particular that primitive legal order was that rule of recognition which provide means of identification of primary rules exist in international law, in that it is incorporated in the statute of International Court of Justice. Rules of change operate to some extent through international treaties and customary law. Rules of adjudication is also there. That means whatever thing he pointed out, all things are in existence in international law. Whether adjudication is there, whether recognition is there, that means the recognition capability is also in international law. We will have the theories relating to this. We will study that theory in recognition. He pointed out there is missing of that adjudication. We have International Court of Justice in existence. The adjudication process is going on. So he tried to point out many things which is not there. In particular, that particular in International Court of Justice, there is particular articles we say that the whatever thing are decided between these two parties, which the parties should basically oblige by that decision. That means you have to follow that decision. So whatever critique that Kelsen has tried to point out, all that critique was basically we can say was not up to the mark, and all have there are different international bodies, tribunals which are basically part of international organization. For example, ITLOS is there, International Court of Justice is there, International Criminal Court is there, Permanent Court of Arbitration is there. So these are different we can say adjudication process are there. So you can't say in WTO there are that dispute settlement system is there. So nowadays everything is there in international law. It was, we can say, in past there were some demerits there, or we can say there were some loopholes, but international law evolved a lot. International law has evolved. That means they are right now comparing with the norms of domestic law, and sometimes they are more than domestic law also. I am saying about the legal reforms. I am not saying about the system, but I am saying about international law have adopted many new rules which are still pending or still not in a discussion in many international many domestic or the states also. So this is basically the concept which whether international law is law or not, international law is uh, uh, strong law is not, whether international is weak law is not. So by in a way we can basically conclude this point that international law is a true law. International law is not weak law, because we already have sanctions in UN Charter also, and other sanctions by Security Council, basically by the using the Chapter 7. They use this particular type of sanctions, and they ask other state to follow this thing otherwise. But there are loopholes. I'm not saying there are not loopholes. The collective self-defense concept is many times misused. The US or this particular superpower countries are misusing that particular system, but still it the international has evolved a lot. This is my basic the conclusion for this class. And we will in the next class we will study about basis of international law, and after that the codification. Codification is very small topic. I will not go deep into that. So this is for this class. If you want any question, you can ask.
No, sir.
सबको समझ में आ गया?
हाँ सर. सर हैंडआउट भेज दीजिएगा, कोर्स हैंडआउट, और अगर ये रीडिंग मटेरियल हो पाए तो वो भी भेज दीजिएगा.
ये हैंडआउट तो मैंने ग्रुप पे भेज दिया है.
हैंडआउट सर में आपने भेजा था.
हाँ, और मैंने एक बुक भी भेजा है आपको. अगर मन करेगा तो पढ़िएगा. ऐसे तो इंटरनेशनल राइटर की है. तो बाकी मैं नोट्स दूंगा आपको. नोट्स मैं प्रोवाइड कर दूंगा. पीपीटी एक बार मैं एक्चुअली क्या है, हमें पीपीटी कंटेंट भी बनाना है, तो मुझे रिकॉर्ड करना है. तो बाकी पीपीटी बना हुआ है, मैं एक बार रिकॉर्ड कर लूंगा तो मैं शेयर कर दूंगा। मोस्ट प्रोबेबली दे वांट इट ऑन आई क्लाउड, तो मुझे शायद आई क्लाउड पे अपलोड करना होगा। ठीक है,
ओके सर।
ओके सर।
बाकी मैं क्लास की रिकॉर्डिंग में अभी यार रेगुलर क्लासेस चल रही थी, और कल ऑफ है। मतलब कल ऑफ मतलब पता नहीं ऑफ है कि नहीं, लेकिन जो भी है तो मतलब कल मैं ड्राइव बना के जो बाकी प्रीवियस क्लासेस की रिकॉर्डिंग है वो मैं शेयर कर